What did the Chamber decide today in the Kenyatta case?
Today, 19 September 2014, ICC Trial Chamber 5B decided that the trial of Uhuru Muigai Kenyatta, provisionally scheduled for 7th of October 2014, will not start on this date. The Chamber also scheduled 2 public status conferences for 7th and 8th October 2014 to discuss the status of cooperation between the prosecution and the Kenyan Government and pending requests from the prosecution and defense. A representative of the Kenyan Government is invited to attend the first status conference, and Mr. Kenyatta is required to be present at the second status conference. Both hearings will be held in the presence of the prosecution, the defense, and the legal representatives of victims.
Why was the trial date vacated?
The Chamber vacated the trial date of 7th October to have more time to consider a number of requests by the parties and participants. This is without prejudice to the judge's ruling regarding those requests. The prosecution has sought the adjournment of the case, pending full compliance by the Kenyan Government with an outstanding cooperation request. For its part, the defense has requested that the case be terminated. Status conferences have been convened on 7th and 8th October 2014 to discuss these pending requests, as well as the status of cooperation between the prosecution and the Kenyan Government. Having heard further submissions at the status conferences, the Chamber will rule in due course on those issues in an independent and impartial manner. The Chamber made its decision with due regard to the requirements of the Rome Statute, which states that the trial chamber shall ensure that a trial is fair and expeditious and is conducted with full respect for the rights of the accused and due regard for the protection of victims and witnesses.
What is the new provisional date? Or is it indefinite?
The Chamber did not set a new provisional date for the trial, as it will first need to address the pending requests by parties and participants to the trial.
Does today's decision mean that the government of Kenya is not cooperating with the ICC?
As a state party to the Rome Statute, Kenya has the obligation to cooperate with the ICC. In March 2014, in the Kenyatta case, Trial Chamber 5B deferred making a finding of non-cooperation to provide a further opportunity for the Kenyan Government to comply with its obligations. It is ultimately up to the ICC judges to determine whether the government is complying with its obligations or not. If the Chamber finds that there is non-compliance, it may refer the matter to the Assembly of States Parties to adopt any appropriate measures.
What does this decision mean for the victims of the case?
The decision to vacate the trial date has been made in order to consider the pending requests from the prosecution and defense and is without prejudice to the Chamber's position on them. Given the importance of the issues to be considered and their impact on the interests of victims, the Chamber has permitted the legal representative of victims to be present at the 2 scheduled status conferences in order to make further submissions.
Why does the accused have to be present at the 8th October status conference?
While true that Mr. Kenyatta has not been required to be present at recent status conferences, given the critical juncture of the proceedings and the matters to be considered, the Chamber deems that his presence is necessary. Pursuant to the terms of his summons to appear, Mr. Kenyatta must attend all hearings at the court for which the Chamber requires his presence.